because we have a brand new case that I have to talk to you about right now. It is out of Iowa, and it is strange. It is the Stanley Liggins case. You might be saying to yourself, why does this name sound so familiar? Because what we are going to be covering for you today, we expect opening statements, is the third trial, the third time this man has been on trial for the death of Jennifer Ann Lewis, a 9-year-old. It is alleged that this man raped, strangled her, wrapped her body in a plastic bag, and doused it with gasoline and set it on fire. Now, this has been a really weird case because he has been convicted twice in 2 separate trials. But because of issues with the prosecution presenting their case, he is actually getting a third trial. This is something very rare, and I want to talk with my very special guest right now, jury consultant Alan Tuerkheimer, about the difficulty in maybe getting a jury for this. So, Alan, welcome to Law and Crime, and great to have you here on the set as opposed to Skype.
Great to be here.
So what is the difficulty? I imagine there is some. We've heard reports that there's a problem getting a jury seated in this particular case. What's going on?
I think it just has to do with the victim and the allegations being so heinous and so terrible that some jurors know about it, they know a little about it, and during the voir dire questioning, when they hear what this case is about, it brings back some really haunting recollections in their mind of what they've heard about the case, and they just can't have any part of it. They don't want to sit there. They don't want to hear about it. They don't want to see pictures. There's just this factor, this factor for jurors that causes a revulsion, and they can't sit there, and they realize that they can't be there and evaluate the evidence the way they should. And
also the fact that this case, we believe this trial will last 3 to 4 weeks. We know that the jury is still being selected today, but we expect opening statements later on. And you know, here on Law and Crime, as soon as we get that live feed, we're going to go to it. But before we talk about any of the cases that I just mentioned, there is so much more happening in the news, and that's what I want to present to you here. Here are some of the top stories trending in the news right now.
Here are today's top crime stories trending on lawandcrime.com and across the country. A teen in Ohio who went missing 6 days after reportedly witnessing his father's brutal murder at the hands of his mother and her lover was found safe in Dayton. 15-year-old Jacob Caldwell was found with 4 adults in a home in Sugar Creek Township after authorities received a tip to his whereabouts. Jacob went missing a year ago after witnessing his mother, Tawny Caldwell, and her boyfriend, Sterling Roberts, murder his father, Robert Caldwell, in front of him and his younger siblings. Tawny Caldwell and Sterling Roberts are in jail facing murder charges, and the 4 adults Jacob was found with could face charges for allegedly hiding him. An unidentified man is claiming he had a 10-month-long sexual relationship with accused killer Chris Watts. Watts is accused of killing his wife Shannon and his 2 daughters, 4-year-old Bella and 3-year-old Celeste. The man claims Watts told him he was trapped in a loveless marriage. In April 2012, Watts released this video offering relationship advice when dealing with why marriages fail.
Sometimes people, when the relationship starts to dissolve, repair is not an option, and they want to get away and start new. When you want to go into repair, you need to analyze what went wrong and consider what ways of solving the problems.
Before Watts was arrested, he begged the public for help finding his family.
I just want them back. I just want them to come back. And if they're not safe right now, that's what's tearing me apart. Because if they are safe, they're coming back. But if they're not, this has got to stop. Like, somebody has to come forward.
Watts now faces 5 counts of first-degree murder and 4 other felony charges. Investigators in Texas are searching for a woman wearing broken wrist shackles and a T-shirt caught on surveillance camera ringing a doorbell of a home before running off. Other neighbors in the Sunrise Ranch area of Montgomery reportedly saw the woman ring several doorbells to no avail before fleeing. Other neighbors in the Sunrise Ranch area of Montgomery reportedly saw the woman ring several doorbells to no avail before fleeing. The identity and whereabouts of this woman remain a mystery, and authorities are investigating the possible connection to a missing person. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
There you have it. The jury found him guilty of murder. We know that the Edwards family has also now filed a civil lawsuit against the city of Box Springs. That's where he was a police officer. And Oliver's defense team has already started the appeals process, not surprisingly. Let's bring in Alan Tuerkheimer to talk a little bit more about this. I have to ask you a question about this. We've seen these cases before end in mistrials where there's a police shooting, and sometimes the police officer is found not guilty. What made this case different in the minds of the jury? What do you think about this, the specific facts that they said, no way?
Jurors like to put together a case narrative and get a story of what really happened. So they get the law and all this information, but they want to know what took place. And to them, they just didn't buy Oliver's story. They didn't believe that he had a reasonable basis to shoot into that car. And it was contradicted by the officer that he said that he was protecting. And there were some other factors that the jurors thought that he shouldn't have done this. And
is
they
it the
didn't buy
fact
his story.
that Edwards also, he had no weapons on him? I mean, he was completely innocent of the shooting. There was nothing tying him to that.
Right. He had no weapons. And also, it wasn't if he was reaching for a cell phone that the officer could have mistaken for a weapon, or he didn't do make any kind of threatening movements. So absolutely that played a part in it. He was an unarmed teenager, which sadly we've seen so much of, but this time it was a different result.
Absolutely. And I mean, it's a tragedy. It's an ultimate tragedy. And we are going to break down the different testimony from this case. We're going to analyze it and try to understand which parts the jury really held on to and which they maybe didn't like so much. We can only guess, but we will analyze it in depth here on Law and Crime. Stay tuned. Okay, so that was Ardell Edwards, the father of Jordan Edwards. Roy Oliver was found guilty of the murder of Jordan, and now was the sentencing hearing. The same jury that convicted him, they have to recommend a sentence of what his punishment should be for the murder of this 15-year-old young man. I'm here with Alan Tuerkheimer, jury consultant, to talk a little bit more about what is the jury thinking when they hear the testimony from the victim's father. And you know how difficult that is for him to get on the stand. But what is the jury making of it?
He's really personifying his son. He's bringing him back to life. And it's a very relatable moment. Jurors hear from experts who are coached and taught how to testify. This is just a human being discussing his son. And he's a little nervous, you can tell. He's trying to be upbeat and moving on. He's very sad, obviously. So the jurors are just taking this in and realizing, essentially, they already came to the verdict, but they're realizing his son was never a threat.
Now, we are going to reveal what the sentence is a little bit later, but before we do, just because a jury convicts him of murder doesn't mean that they're going to be extremely strict or harsh in their penalty, right?
Right. It can be completely the opposite. They can find that there was an infraction of the law or violation of the law, and then decide, well, there are some other factors. Maybe it could be a compromised verdict in a way, where they come to a verdict, but then when it gets to the sentencing phase, the voices that talk about leniency are the ones that dominate the deliberation.
And the prosecution is going to be very ample about really putting in as many factors to show why this guy was a very aggressive police officer. And that brings me to the testimony of Rosalinda Medina. She testified also in the sentencing hearing, not in the trial, but at the sentencing hearing. And she is going to talk about an incident that happened with Roy Oliver that she definitely wants the jury to think about. Take a look. That's Rosalinda Medina testifying in the sentencing hearing of Roy Oliver. As we keep saying, he was found guilty of the murder of Jordan Edwards, and now the same jury that convicted him has to recommend what his sentence should be. How many years in prison would they recommend? And we know what they said, but we won't tell you what their sentencing verdict is until a little bit later on. Let's bring back in Alan Tuerkheimer to talk about this. What do you think the jury is making of this? This is not the first incident that they've heard of Roy Oliver. They obviously know about the Jordan Edwards situation, but during the trial, they also learned that a few weeks before the Jordan Edwards shooting, he was involved in a road rage incident. So what is the jury thinking about all these stories?
So they heard the emotional piece from his father, Ardell, and this is the part that's really going to fuel.
I apologize. I think it's Odell. We apologize.
Oh.
There was a spelled it incorrectly, so it's Odell.
Odell. Okay, so Odell was the emotional piece. The jurors were completely saddened to hear about that story. This is going to fuel a little anger. They're going to realize that perhaps this officer should not only not be a police officer, but he shouldn't have been walking on the streets. So this is a pretty important bit of testimony that they're going to use to evaluate perhaps a harsh sentence.
How does a jury come up with a sentence here? Honestly, it seems a little rare that a jury would recommend what a sentence should be, but they are going to have to do that here, and they did do that here. How do they come up with that?
It's very difficult. It's like damages in a civil case. It's something that they're not very used to, and they don't have a lot of basis for comparison. They don't do it in everyday life. So a lot of it just turns out to be some jurors throw a number or an amount of time out there. Others talk about it, and they sort of work to a midpoint and a compromise, and then at the end, they try to get everybody to agree to it and see it with one voice.
Seems fair in our system when a jury has to determine death or life in prison, but do you think it seems fair for them to recommend a sentence of how many years in prison?
I think it is because it's a recommendation, but judges they do take it pretty seriously. But there is something a little disconcerting about it. People have unease with it because these are jurors and they're not as familiar with sentencing, and they don't have the guidelines that judges have. So it is a difficult part of our system that we struggle with.
Yeah, it's definitely a little quirk, and it's something we always learn. So we learn something new here on Law and Crime. Now, when we come back, we've been playing you so much of the prosecution. We're going to play you some of who the defense put forward in the sentencing hearing, including Officer Oliver's mother. Okay, so that was the defendant's mother. Think about being in her shoes for a second, because this is a horrific crime, but there are people who suffer on both sides. Alan, when you listen to that and you try to understand what the jury might be thinking there, I don't know if they were expecting this. She really, really was an emotional, in my opinion, a strong witness for the defense in the sentencing hearing. What do you think?
Yeah, she's tried to tug at the heartstrings of some of the jurors as they're about to make this big decision, and she brings in the grandson, Oliver's kids, just to make the jury aware that there are other victims here, and are you really going to impose a long sentence where then the father's going to be in prison? I'm sure, I have no doubt, that there are some jurors that are going to bring up or that are thinking, well, Edwards, or what happened with the boy who was murdered, he's never going to be able to have a son, and their parents don't have a son. So there is a contrast going on, but this is what they have to do. They have to try to get the jury to realize that there's another victim here and that they should be lenient.
Does that work? Does the jury consider the family members of the defendant?
It's a consideration, and I think this is important testimony. This has to be brought out, and so they're doing exactly what they're supposed to. It's just a question of whether or not the jurors are going to give more weight to some of the other elements that they heard in the prosecution's part of the sentencing hearing versus this.
I know you have interviewed a lot of jurors. I know you think about their psychology when they go into this. What do they think about when an attorney cross-examines a sensitive witness? Because what we're about to play in a minute is the cross-examination of Roy Oliver's mother. What are some things juries like, and what are some things juries say, hey, that's off limits when you cross-examine, even in certain cases when you cross-examine a victim? So what is the trick there that a jury says, okay, that's acceptable?
Right, you alluded to it. There's a certain point, a balancing act that has to take place, and there's a point where you can elicit testimony in a factual way that's going to be beneficial, but if you cross a certain line, it's going to cause a backlash, and then the jurors are going to come to the defense of the witness if they think that the attorney's pushing the witness a little too far or trying to get things committed in an aggressive posture.
Okay, well, let's see. Let's see how the prosecution did when they cross-examined Roy Oliver's mother. Okay, that was an interesting moment. The mother of the defendant talking about the father and the parents of the victim. Let's talk about it with Alan right now. That's an interesting thing. What's the prosecution going with there, trying to have her acknowledge what happened?
Yeah, it's setting up a contrast and getting the mother to concede, look, you're talking about your grandkids as a victim not being able to see their father except in prison, but let's take a look at the broader picture. Who else is a victim here? And really, who is the real victim here when you have a 15-year-old who was shot and their parents are never going to see that person again? They would prefer to see their son anywhere, but they can't see him anywhere. So it's this contrast that they're setting up.
Does the jury have more difficulty determining guilt or innocence as opposed to what the sentence should be?
I think it depends on the case. I think in this case, I think the sentence is going to be more difficult.
I mean, they have a range of 5 to 99 years. That's a pretty big range, where everybody has their own perspective.
Exactly. It's so hard to do that, where there's more limited choices, and they're more familiar with the terms when they evaluate guilt or innocence and the circumstances that brought them here. But with the years and the ranges, it's really hard. It's an amorphous concept that jurors are just not used to, so they do struggle with it, and I think they are in this case.
I know every case is different, but sitting on this trial must have been difficult for them, in your opinion, seeing these kinds of tragic circumstances, right?
Absolutely. Whenever somebody dies, it's a tragic circumstance. And then you go through these layers, and when it's a 15-year-old, it's more tragic. And it becomes more and more tragic. He wasn't doing anything. He didn't do anything to provoke the officer, which they concluded. So it's an awful set of circumstances.
It really is. And as we say, there's people on both sides who've suffered, including Ingrid Urena. That is the wife of Roy Oliver. And we are going to play her testimony right after this. Okay, so the defense brought out the wife of the defendant in an attempt to get leniency from the jury when they ultimately recommend their sentence. Alan, when, in your opinion, or when have you seen juries who have convicted a defendant be lenient in their sentence?
It's when the defense can get up there and show that what happened, the conduct was an aberration, that otherwise, and it's what they're trying to do, otherwise in this person's life, he was very dedicated, very caring, very helpful, and then the jury can say to themselves, it's hard to do, but then they can say, all right, yes, we just convicted this person, but let's take the bigger picture into account, and that's what they're trying to do. The defense is trying to cast a wider net of people who are caught up negatively and negatively impacted by these circumstances.
But they didn't find him guilty of manslaughter. They found him guilty of murder, and they had the choice of manslaughter. What does that tell you?
Right. Now that makes it a higher hurdle. That means that they're really going to have to dig in and try everything they can to attain a more lenient verdict. It's not easy because you're right. There's a lot of momentum that takes place in deliberations, and so the jury just came off the higher conviction of murder, not manslaughter. And so while they're doing that, it's hard to just step on the brakes and then shift courses completely. It's a tough task.
Okay, so the jury that convicted him had to figure out what a sentence should be. They had a range, 5 to 99 years. We were about to play you the sentencing in the Roy Oliver trial. Take a look. Roy Oliver, sentenced to 15 years in prison and a $10,000 fine. Alan, how did the jury come to 15 years? He's 38 years old. He'll get out when he's 53 years old, if none of the appeals work and he doesn't get out earlier. But what is going on? How did they come up with 15 years and a $10,000 fine?
That's a great question. I can tell you how they didn't come up with it. They didn't say, okay, once they started deliberating, let's say, how long should he be in prison for? I guarantee they all didn't say 15, 15, 15, 15, 15. I'm sure there was some give and take. My guess is that the jurors went around, they started talking. Maybe 9 or 10 were saying, no, it should be 10 years, and then maybe a couple jurors were saying, no, it should be 50 years. This type of thing usually ends up as a result of a compromise.
Isn't it fascinating, though? They're thinking about how many years a person will serve in prison. I'm saying, hey, let's add 2 more years. Let's take away 2 more years. These are years. These are years to a person's life, and trying to balance the interest of Jordan Edwards, who has no more years. His life was taken away from him, and trying to balance this man with his family and taking away from his family. It seems like an impossible situation.
Yeah, exactly. And you're right. You talk about it, I mean, a year can seem like an eternity when you're in prison, but the way they usually talk about it, it's usually in intervals of 0 or 5. So just saying, okay, let's add 5, let's take away 5, the way it's done, it might seem arbitrary. It's the system and it's how they're doing it. But yeah, you're right. It's very difficult.
38 years old, they didn't give him life in prison, which they could have.
Right. Right. They realized, and of course, they talked about that. They realized how old he's going to be when he gets out, when he's 53. And
that's a full life.
Yeah. Jurors, they took that into consideration.
Fascinating case. We are going to switch gears here on Law and Crime. When we come back, we're talking about the Angela Kilgore case. Some wild and incredible stories. Thanks, Anthony. Go to lawandcrime.com to learn a little bit more about the top trending stories of the day. Want to switch gears here and talk more about the Angela Kilgore case. This woman was on trial for the murder of Jerry Don Ridge, a pawn shop owner. She allegedly stabbed him, shot him, and then burned his body to hide the evidence. Let's bring back in jury consultant Alan Tuerkheimer. Alan, what is the trick for the prosecution in getting a jury here? What kind of jury do they want for this kind of case?
They're going to want a jury that will keep an open mind in terms of evaluating the evidence as it comes in, and really they have a strong case. I think there's solid direct evidence. A lot of cases, as you know, are circumstantial, but they have some pretty strong evidence. So they just want to make sure they have jurors that aren't going to stray too far from the big picture, jurors that are going to not necessarily align with the defendant in the beginning, and jurors that are going to be open and willing to defer to the prosecution's theory of the case.
Well, let's see if they were open and willing to defer to the prosecution's case, because I want to start off where the prosecution started, with their opening statement. And let me tell you, it was pretty strong. Take a look. I wasn't joking. Pretty strong opening statement so far by the state there. And I want to talk with Alan about this. Alan, I love a good PowerPoint. When I was in law school, loved it, helped break things down. But do juries like it? It seems pretty clear here, or are they more confused?
Jurors like PowerPoints. It's once in a while you get somebody who's very old school, but nowadays with the way our attention spans work and the way we process information, whether we're here in New York or Chicago or Marion County, Tennessee, jurors are so people in general, but jurors are accustomed to processing information visually. They learn about it better and retain it more when they see it in addition to hearing about it.
And the opening statement, correct me if I'm wrong, is critical for the prosecution and the defense, but for the jury, right? I mean, how much do they take from that and when they ultimately deliberate and say, I remember that from the opening statement? Because the evidence can get kind of confusing during the actual case.
Absolutely. The opening is an organizational framework that jurors are going to take with them throughout the case, and they're going to make up their minds, not necessarily be committed to it throughout, but early on, opinions are formed, and it's the opening statement where jurors are going to start to take things and then remember them. And so once they see things in the opening statement, when the subsequent evidence comes in, they're going to filter it through those pre-existing memories of what they saw in the opening statement, so it's crucial.
You think that was a strong opening statement?
Very strong. A lot of evidence that the prosecution's offering.
And they labeled it out pretty well, right?
They did. The way they did it with PowerPoint is a nice mix.
You know why I'm teasing this? Because when we come back, we're going to play the defense's opening statement, and I really want to hear your perspective on that because for lack of a better word, I guess it was a little different than the prosecution, and I want to know from your perspective what the jury will ultimately think of that, because we are talking about the Angela Kilgore case. This woman who was on trial for the murder of Jerry Don Ridge, a 72-year-old pawn shop owner. It's a really horrific crime, and we will let you know what the jury ultimately rendered when they handed down their verdict, but not yet. We'll be back after the short messages. Stay tuned. Well, what have we learned from the defense's opening statement? That DNA is confusing and that the victim and the defendant knew each other. So how is it possible that she could have killed him? Alan, what do you think about that?
I've seen openings that are a little more impassioned.
That's one word to explain it. Yeah. What's the point of that opening statement? I have to ask, because it didn't seem all that together cohesive and didn't seem very strong.
Right. It was definitely disjointed. I think it's always helpful when you can give an opening and you want the jurors to be able to say, okay, in a sentence, what is this case really about? This case is about, according to the defense, and you want to be able to just say that in a concise sentence. I don't think he was able to provide that to the jurors.
So what's the jury thinking? This is the first time that they're hearing the defense's case, the first roadmap about where to go, and they're left with wait till the end and just wait. I mean, that's not the worst strategy, right?
Right.
So don't make up your mind immediately.
Right. You want him to hold off, and he's hoping something down the road might reach out to one juror, two jurors. Maybe he thinks that he can get all the jurors. It's a very unusual opening. I mean, it wasn't. Like I said, you want to deliver a passionate opening, and if the jury sees that the lawyer is maybe monotonous, then it might cause them to pull back a little bit. And also this point about DNA, when you give an opening, you want to empower the jury, and you don't want to be condescending at all. And I think it would be better to, even though we can't embrace the DNA for his case, to say it's confusing. I don't think jurors really are receptive to that. It's confusing stuff. No, they want to learn it. They want to be into the science and grasp everything.
How much do jurors grab onto an attorney and say, I like him or I like her and I want to follow the case based upon that person? Because you heard the prosecution's very strong opening and then you heard the defense's. So what are they supposed to make of that?
Sure. There are different schools of thought. There's the halo effect where in social psychology, it's where if they like the attorney, will it continue on and shine well on the client? But in terms of trials, jurors can separate. So in some cases, they can dislike an attorney and still feel for the client. In fact, in some ways, if they dislike an attorney so much, in some cases, they might actually think, oh, wow, then I feel really bad for this client, and there's some sympathy. But usually there's a correlation when jurors talk about verdicts after a case.
Okay. Well, we'll talk about the verdict in this case in a little bit, but let's move on to the key testimony, and we're going to start off with Detective Matt Blancett from the Marion County Sheriff's Department, one of the key investigators in this case. Let's find out what he found.
Yes.
Okay, so you're listening to how the prosecution is tying the defendant, Angela Kilgore, to the murder of Jerry Don Ridge, that pawn shop owner whose burnt body was found in that pawn shop. I'm here again with jury consultant Alan Tuerkheimer. This is a pretty gruesome crime. You got a victim who was stabbed, shot, his body was burned. He's an elderly victim, I believe 72 years old. Is it tough to get an unbiased, receptive jury in this kind of case?
It is hard. It is, because certainly there was some media attention surrounding this. But yes, it has this very vivid visual factor. And when jurors come to when they show up in the voir dire during voir dire, they're told about what's to come. And so the attorneys should have, if they did their homework, explained to the jury what they're going to get themselves into, and that it's going to involve some very graphic images, some really horrific incidents that took place and allegations. And so some were probably excluded because of that. The ones that made it through are ones that said, you know what, I can handle it, I'm prepared, I'm ready to hear the evidence.
We're in New York City. I'm always fascinated by small-town murders, small-town situations. Do you ever have a jury where they know the victim?
It happens sometimes, and then, I mean, it's when that happens, that a prospective juror would usually get excluded, would always get excluded, but there are some really small connections in a lot of these small towns. I don't know if that happened.
And they still sit on the jury?
I've never worked on a case where that actually happened,
right.
But certainly there are cases where somebody's on the jury where they know of the victim. And
right.
The connection's a little more flimsy.
I mean, I keep talking because the defendant knew the victim, so how could she have done it? We will take a quick break. We'll be right back. Stay tuned here on Law&Crime. Welcome back, everybody. We are talking about the Angela Kilgore case, and we will reveal the verdict to you, but a little bit later on in the program because we have so much to analyze. But before we go back to discussing this case, unfortunately, I have to sign off my guest, Alan Tuerkheimer. Alan, it was great having you here.
It's great being here. Thank you.
You got to come to set more often.
All right. Sounds good to me.
All right, everybody. So what we're going to do is we're going to continue on. Remember, this is the woman who was on trial for the murder of Jerry Don Ridge, a 72-year-old pawn shop owner. I want to play the testimony of Darby Hutchinson, a TBI special agent who really investigated the origin of this crime and how this all happened. She did the initial walkthrough. I want to play some of her testimony right now. Take a look.